My easement video from last week absolutely exploded, and you guys had so many questions that I couldn't possibly answer them all in the comments. So today I'm answering your top 25 questions about easements. I'm Tiffany Weber, real estate attorney in North Carolina at Thomas & Weber. I've done thousands of closings, and easements come up all the time, so I've seen it all. I'm going to rapid fire through your questions, giving you answers based on some actual cases I've handled. Again, not specific legal advice, just general legal information. Some of these answers might surprise you, and a few might save you thousands of dollars. Now, keep in mind that easement law can vary by state, so while I'm speaking from my experience in North Carolina, the general principles will probably apply nationwide. Let's get right into your questions. Whose responsibility is it to take care of sidewalks in one's easement? Who put the sidewalks there? Is this like an HOA? Is it a town? Typically, those types of easements where a sidewalk is allowed to be put in will be something that's an express easement, meaning it's been written down and recorded. You will look to that document to see who is responsible to take care of the sidewalks, probably whoever installed them. For example, the HOA. If my driveway is an easement to other properties, who has the right to use it? In this case, only the properties that it's necessary to get to their property. And this would be like the property owners, their guests, their invitees, etc., someone who's actually going to the property. But again, look to your easement document because it might limit it to certain properties, even if someone else might be able to use it to get to their property. Can an owner demand monetary compensation for granting an easement? They can, depending on the circumstances. So if this is just your neighbor coming to you saying, hey, we want to build this, subdivision back here and we really need an easement across your property so that one of the lots can get where they need to go, you don't have to just say yes without money. So how you value what that's worth to you, it just depends on how much his property is being used. You could get an appraiser, etc. Can I plant trees or build a fence on a landscape easement? You have to look to the terms of the easement to do that. Most landscape easements are actually written down. I personally have not encountered a landscape easement that wasn't recorded in the Register of Deeds, though I'm sure it's happened somewhere. And in that case, they'll tell you what kinds of landscaping can be maintained by whom, what areas can or cannot be blocked. So most likely, yes, but you're going to have to look to the terms of the written document. How do you get rid of easements? Well, there's a lot of different ways to get rid of easements, and it depends first on how it was created. So if it was written, then by written termination by the person who is benefiting, and by person I mean the landowner or landowners. It may not be the original person it was granted to. It might be their successors in interest. There could also be litigation that would get rid of the easement due to the scope being exceeded. There's this thing called merger, meaning that if you buy a property that had an easement over your property, well, once you own both of them, that easement gets extinguished. There could also be eminent domain factors or foreclosure that could get rid of an easement. Are easements perpetual? Once a property owner grants an easement to someone, is that easement effective in perpetuity and binding on all subsequent owners? If the language in the easement says binding on heir successors and assigns, yes, it is perpetual until whatever termination triggers there are in the document get triggered. So whether that's exceeding the scope, some time limit on it, some other condition being met. But if there are no termination conditions and it has that heir successors and assigns language, then yes, it would be perpetual. I do want to point out there is another type of easement that can be, it's called an easement in gross, that is for a person specifically. So once that person no longer owns the property, it would be gone, but that would be very specifically laid out. I have an easement on my property to accommodate a neighborhood mailbox. Who is responsible for maintaining that area? Weeds, litter, debris, etc. I'm going to sound like a broken record here. You're going to have to look back at the actual recorded easement document, and the maintenance probably depends on who caused the issue. So if I'm guessing this kind of situation is most commonly in an HOA neighborhood, the HOA gets an easement for maintaining the mailbox. So they would have to keep the mailbox in good repair, probably including weeds in the specific area. But let's say if it's on your property and you do something that causes the area to need to be maintained, then you would have to basically clean up your own mess, so to speak. Why do we have to pay taxes on an easement if someone else can use it? That is because, unfortunately, taxes go to the fee simple owner of the property. So whoever is the owner is who is getting the tax bill. That doesn't mean that you can't negotiate some sort of compensation in your easement for a proportionate share of the taxes, or you decide, hey, I feel like, since I'm going to have to settle the tax bill, but you can use this much of the property for this much purpose, that is worth X amount of dollars to me. This one's not a question, but it is a very good statement, and I wanted to make sure to include it here. You forgot to add, easements are only granted to certain people for which they are intended. They do not grant free gratis to all. If you have a drainage easement across the back of your property for the water company, that doesn't mean the neighborhood kids get to play in it. Exactly. I wish I had said that myself. That is exactly right. An easement is for the party, that it's intended. And that might be a property owner. It might be a utility company. It might be a specific person, but it is not a free-for-all. What if there is a dead and dangerous tree on the easement? I have no idea who planted it, who would be responsible for that tree. It kind of doesn't matter whether you know who planted the tree. It's more about whose property is it on. And that would go back to, in a lot of cases, the property owner. There could be certain circumstances where, let's say the easement holder did plant that tree and they created in themselves some right to or obligation to maintain the tree. But in a lot of cases, when it's unknown who planted the tree, then the responsibility could end up back on the property owner and not on the easement holder. Can I get this easement and perhaps a power line removed since it serves no useful purpose? Where would I start? Well, for utility easements in North Carolina, there is a process where if a utility easement hasn't been used for a certain amount of time, don't quote me on this, I think it's 20 years, that you can apply for the easement to be abandoned. And that might be with like the North Carolina Utility Commission. Again, don't quote me on it. I'm kind of trying to remember from a weird situation like 10 years ago. So it's possible that you could get a utility easement abandoned if it truly is not being used with the proper application to the utility. Can you remove a utility easement if it's no longer being utilized? See the answer above. Is it a hassle to have an easement moved? It can be, especially if the parties that are, the benefited parcel and the burden parcel don't agree about where it should be moved or if it should be moved. This is something that cannot be done unilaterally. Everybody involved has to agree. I own a property with a driveway easement on it. The neighbors are driving very fast on my driveway. Can anything be done to slow them down? That's a really good question. I'm assuming that you've probably already had the conversation with them to slow down, but depending on the terms of the easement, there may be something that could be done as in terms of materials, maybe even speed bumps or other methods that can slow them down. But before you take any action, this is one I strongly encourage. Do not act without consulting a real estate attorney in your state. What is a plat? A plat is a drawing of typically a subdivision of properties, unlike a survey, which is a drawing of one property, but a plat would be a subdivision of property showing setbacks, the typical location of any utility easements, any rights of way in the neighborhood, etc. So not a question, but also kind of a question. I thought easements and rights of ways were two different things. They can be, but sometimes they can be used interchangeably. So you can have a driveway easement, and a lot of people would call something that you can drive on a right of way, or a right of way easement to get to property that is landlocked. Right-of-ways are typically used to describe an area where you drive. So not all easements are right-of-ways, not all right-of-ways are easements, but they can be. Do I have a non-possessory right to walk between a home and the street if there is no sidewalk? Probably not. The sidewalk would be a good indication that there is in fact an easement, though that's not a guarantee, but it is a really good sign. But without the sidewalk, then there's no indication that you actually have the right to walk there. And there's no like common law, hey, just this area next to the road is considered an easement for anyone to walk. So you'd have to look at a survey. You'd have to see where exactly a street ended and where a property began. And I'm not sure that it is economical to get properties surveyed without a sidewalk to determine exactly where you have the right to walk. Can easements granted by former owners be rescinded or modified? The person who granted the easement in most cases cannot unilaterally revoke or change an easement. You would need the consent of the property owner that's benefited. So that's, I've talked about in other videos by termination. The burden parcel can't unilaterally terminate or change an easement, and that's because they're the ones that are burdened. The benefited parcel is really the only one that can unilaterally say, I don't want this anymore. They can't change the terms of the easement, but they can say they don't want it. In most cases, no, a former owner could not just decide they were going to revoke or change an easement. Can they use easement without without letting the owner know? Depends on the type of easement. That's a very lawyer answer to say. For example, a driveway easement. You're not going to have to call the landowner every time to let them know that you're going to drive over the driveway to get to your house when you have the right to do so. There are other types of easements where the parties may say, yes, you do have the right to, cut through the farm to get to your deer stand, but we need advance notice of X amount of time because we don't want the cows getting out. And that could be negotiated among the parties. But for example, a driveway easement, you're not going to need to call unless you specifically agreed to that. You're not going to need to call and say, I'm going to use the driveway. Who is liable for injuries sustained on and while using an easement? The homeowner or the person using the easement? This is going to be highly dependent on the injury, basically what caused the injury. And, this is kind of like looking at personal injury law and, theories of negligence. Who had control of the condition that caused the person to get hurt? Was there someone that, is acting negligently that caused the person to get hurt? That could be the homeowner, or it could be the easement holder. So that is too fact specific to just give a blanket answer to who's going to be liable. In some cases, it could be both. Where do you find out what easements are attached to your property? That, my friend, is the Register of Deeds in the county where your property is located, and that would be found out through a title search. It would have been useful to know whether easements need to be recorded to be valid if they're not shown on your plat, as well as if they need to be mentioned in the legal description on the title. Also, whether or not the easements run with the land in perpetuity by default, and how easements can be vacated if the easement holder chooses to give up their easement rights. I've touched on how to get rid of easements if the person that has the right wants to. That's by written termination. Whether it runs in perpetuity, we've discussed, but we did not discuss the beginning part of the statement, which is, does this have to be recorded in the Register of Deeds and mentioned in the legal description on the title? An easement by grant needs to be recorded in the Register of Deeds. If you have an easement that you've obtained some other way by necessity, implication, prescription, etc., then that would be formalized by a quiet title action in court and then recorded in the Register of Deeds. So just because you obtain an easement by some other method, you would, to formalize it, need to have it ultimately recorded somewhere. Not every easement has to be mentioned on your deed. If it is recorded in the Register of Deeds, that can be sufficient. There are some types of easements that it is best practice to record in the deed, though certainly not required. And not every easement that applies to your property will be mentioned on your deed. For example, utility easement you will likely never see on your deed. What if a property is landlocked and the only way to it is through a utility easement and a verbal easement agreement? There is no written easement, but there is a verbal agreement. Typically, a utility easement would not be used for vehicular access and really would be for the utility company and not for anyone else. Otherwise, a verbal easement agreement, you may ripen into something formal, but if you don't have a written agreement, then there are not a lot of cases where that would transfer to subsequent owners. It might be sufficient for you to have permission to get to your property, but without it being in writing, then there's not a whole lot of protection there for later owners, or if the person that's given you permission ever changes their mind. I have been using a path that crosses my neighbor's land for 15 years. The land is unoccupied. Do I have to file anything, or does it become my easement automatically? In North Carolina, we already have an issue in that it hasn't been long enough. In North Carolina, to get a prescriptive easement, which is kind of what this question is asking, you have to have adverse, hostile, open, notorious, exclusive, continuous use for a period of at least 20 years. 15 years in North Carolina would not be long enough. If you believe that you have a prescriptive easement in North Carolina, then in order to get that fully settled, you would file a quiet title action to get your prescriptive easement formalized. But there's nothing necessarily automatic about it. What's the difference between an easement and a setback? Well, an easement is a non-possessory right to use someone else's land, and a setback is some distance from your property line that you are not allowed to build. So there you have it, 25 of your most pressing easement questions answered. And here's the thing, easements are way more common than you think. In fact, there's probably an easement affecting your property right now that you don't even know about. But wait, I just realized something. Several of you ask about prescriptive easements and how someone can actually gain rights to your property without your permission. That 15-year question, that person might only be 5 years away from potentially owning an easement across their neighbor's land. This is exactly why you need to watch my video on how easements are created and destroyed. I break down all the ways someone can gain an easement on your property, including the one way that happens without you even knowing it. And more importantly, I show you how to stop it before it's too late. That video is right here. You need to watch it now before someone claims rights to your property.